78, 79.
కేస్ నెంబర్ చెప్పండి, రేపు ఇంకో రోజు వచ్చినప్పుడు
25 of 2020. 2025.
ఓకే, ఇంకా
77.
డబ్ల్యూపీ నెంబర్
5904. 70.
తీకర్లే చెప్పండి. చెప్పండి.
Only short point more in cases. As per the notification, full 4, the age limit has been fixed at 26 years, amended to 28, wherein it specifies the
ఏజ్ లిమిట్ ఇన్ నోటిఫికేషన్
notification 4,
క్లాస్ 4
fixed as 28. Initially it was 26 and amended to 28. The petitioners in these 3 petitions are aged about in between 32 to 33. Page number 39. Rule, I will read only the rule 4. The recruitment of the post of so and so is being as per the provisions of AP Police Stipendary Credit Training Rules 315 dated 13/10/1999.
Okay.
This AP Police Stipendary Credit Training Rules is important. Now that rules you lordship may kindly see at page number 248.
those rules say okay. Three Q, 3A, qualification. Okay.
The qualification of academic, age, physical standard for various categories shall specified in Annexure 1 appended to the rules. The upper age limit under class B, C, sub-rule 1 of Rule State Subordinate Service Rules 1996 shall apply. The Andhra Pradesh State Subordinate Service Rules 1996 shall apply. Now, lordship, I kindly see Rule 2 of Rule 12 of AP State Subordinate Service Rules 1996. rules 12.5. The age limit prescribed is 34 years. Rule 12.5. Clause B 1. (34 years). Lordship may again 5B. Lordship may kindly come to 5B. The maximum age limit prescribed in the special rules for direct recruitment to a post shall be raised uniformly by 5 years. Clause B1. The state subordinate service rules.
This rule itself says 30 years on the Mari. This rule 3A speaks of age limit.
This is 34.
248.
Rule that does not speak about the upper age.
Upper age limit of
once again.
1996 shall apply. The upper age limit of home guards who fall within the definition of these.
That is for home guards. I am direct recruit. Serial number 77, 78, 79 are direct recruits. I have general category. I am not home guard.
సీరియల్ నెంబర్ అంటే ఇవాళ ఒక నెంబర్ ఉంటుంది, రేపు ఒక నెంబర్ నెంబర్ చెప్పాలి. అక్కడి నుంచి అదే చెప్తున్నాను.
5904 WP 5904 WP 6025 WP 6027. WP 6027 is concerned with open category, OC candidates. WP 6025 is connected with SC and STs. And WP 5904 is concerned BC candidate. My respectable submission is, as per Rule 12.5 applies to general category, the maximum age limit is 34 years. As far as the BC and SCs and STs are concerned, Rule 12.5B1 will apply. That will be increased to the maximum age limit prescribed in the special rules for direct recruitment shall be raised uniformly by 5 years in case of candidates belonging to the SCs or STs is specified in the Schedule 1 of these rules. So, SCs, BCs, STs are concerned, their maximum upper limit age limit is 39 years. This is my respectable sir. As far as OCs are concerned, upper age limit is 34 years is my concern. My respectable sir. As far as 5904 repetition is concerned, there are 6 candidates. Their ages I have mentioned in days in a tabular form in page number 13 of the writ affidavit. Their age is below 32 years as far as the BCs are concerned. That is 5904. As per OC is concerned, that is writ petition 6027. His age is OC candidate. His age is 33 years.
ఎవరిది
6027. OC candidate. His age is 33 years. As per writ petition 6025 is concerned, there are altogether 31 candidates belongs to SC STs. In page 20 of my affidavit, page 20 of the writ, I have mentioned their age. Their age is below 33 years. Even in SC STs case also. In these three matters, I have filed IA2 of 2025. In all the three matters, IA2 has been filed for amendment of prayer, questioning the notification itself. Why? Because in the writ appeals, they have the first
Go of 25 in which writ petition, WP?
3 writ petitions, same number has been allowed. IA2 amendment application. Since writ appeal, the government has taken an objection that notification has not been challenged. That's why I have filed that. That is my response. That's all.
Just filed an amendment petition. Counters need to be filed. Is the questioning the note?
It's only on the ground of age that you can answer it.
Your lordships, kindly said. However, in the notification, at page 6 of the notification is issued in furtherance of the not the state subordinate services, but there are separate rules that are framed. Under those rules, your lordship, this is given page 6 of the notification. The age limit, it says 18 years, all the candidates must have attained 18 years, must not have attained 18. Taxation is 5 years per economically weaker section, 5 years if they belong to BC, SC, ST. Therefore, till 29 years, they have wage relaxation. And this is framed, your lordship, by way of separate set of rules. They are governed by another set of rules, not the state and subordinate. Therefore, I'll bring to your lordship's rules. As the other matters are concerned, your lordship, learned ages before a special bench today. It's with respect to the medical matters, and it's been taken specifically today. And may I just begin, Your Lordship, so that Lordship may kindly take up WP 225825, which was the sixth written. And first, Your Lordship, to come to page 221. This is the order passed in December 2024 in the public petitions. Page 220. Page 228, Your Lordship. Is sum and substance contentions of the petitioners raised in page 228, para number 8.
Okay.
The main grounds on which these writ petitions were filed are as follows. Home guards are to be treated as a special category, and the minimum marks prescribed as per clause 20 do not apply to that category. The second respondent should have prescribed separate cutoff marks for home guards, being a special category by itself. No cutoff or minimum marks are prescribed to the home guards in the notification. After the results were declared, petitioners came to know that they were equated with direct recruitees, since the home guards were treated as special category and posts were reserved. Taking away that privilege without indicating the cutoff marks is arbitrary. Even if Rule 22 of subordinate service rules is made applicable as per the notification, rule of reservation needs to be followed horizontally on a compartmentalized basis by adjusting the selected candidates in the respective category from out of the home guards separately. Second respondent failed to extend ratio in so and so regarding local candidates. Ratio in judgments earlier to the notification to prepare separate merit list, treating the home guards as a special category. Heard 2. Even after declaration of the preliminary written test, state now can relax the rules. This is the sum and substance of the contention. With due respect, Your Lordship, all the contentions raised right now before Your Lordship are covered in the earlier round of litigation. And all these questions were answered by the learned judge. Page 231 onwards. It is a consideration of this honorable court.
Sorry. Page.
Page 231, Your Lordship. Para 10 onwards. This is the consideration by the honorable judge. I'll take Your Lordships to the Under this, Your Lordship, all the rules have been considered, the state and subordinate service rules, as well as the special rules, that is the AP Police Stipendiary Cadet Trainee Rules 1999. They were also considered, and it was concluded that providing for compartmentalized horizontal reservation was treating the home guards as a special category and giving them due benefit of reservation as a separate class. That was done by virtue of separate amendment by virtue of GO 87, and it was found to be legal. Page 243, Your Lordship, may kindly come. 243, paragraph 23. Paragraph 23, Your Lordship. Several judgments pertaining to compartmentalized order of reservation were also discussed. It's in fact a very detailed order. Because earlier, Your Lordship, by virtue of the earlier GO, they did not have the compartmentalized horizontal reservation. That's when the first round of litigation took place. Thereafter, an amendment was issued in which this reservation was granted, and that was conferred on them.
In this case, reservation is not an issue.
Because they were to have separate class and separate merit list was to be prepared according to them. And also their contention was that separate marks also need to be considered. Cutoff marks should be treated separately for this class of candidates. Is the contention that was raised.
This issue which is raised in this case, I don't think is addressed in this judgment. The judgment which you are referring to, I don't see anywhere. I've gone through it.
Is the issue that is raised right now, Your Lordship, is that home guards need to be treated as a special category, number one. And the unfilled vacancies that are there, they have to be filled with home guards alone. They cannot be merged with the general candidate vacancies. That's point number two. Third is the percentage that is reserved for home guards. The percentage of marks for home guards. The minimum marks, there are no fixed minimum marks for home guards specifically. This point was also raised.
Raised, but it was not addressed specifically. They only said in the concluding paragraph.
There was, in fact, comparison made with servicemen as well.
Oh,
And then it was discussed. I'll take Your Lordship's para by paragraph. Page 243, Your Lordship may kindly come because the prior paragraphs, they all deal with compartmentalized horizontal reservation alone. This is the conclusion about that aspect. Para 24, Your Lordship may kindly see. Out of 1167 posts reserved for home guards in civil and APSP, at the hearing, it was brought to court's notice that only 150-160 candidates are qualified in preliminary written test based upon the qualifying marks prescribed. This court resumes that substitution of 2-3C by incorporating the words horizontally compartmentalized is a result of the order in OAS batch. The tribunal directed the authorities to prepare a separate inter-se seniority among home guards. To meet such a contingency, the legislature thought it fit to amend the rule and accordingly amended the rule. Having amended the rule, authorities should have prepared a separate inter-se merit list among the home guards, it being a special category. In all fairness, second respondent should have prepared a separate merit list for home guards, keeping in view the ratio in aforementioned orders. Therefore, there is a direction to prepare an inter-se seniority, inter-se merit list for home guards, which is done. Pursuant to the direction, it was implemented.
This case also deals with the same notification.
Same notification. Initially, they filed this because they could not qualify the preliminary written test. Thereafter, they got an interim order permitting them to participate in the other rounds without having reference to their qualifications. They were directed, the respondents were directed to permit them to the further rounds. Thereafter, this order came. Since 2022, Your Lordship, it is pending. The notification is 2022.
This case is pending from 2022.
Notification is 2022. Writ petitions 23-24.
So difficult to recruit.
After preliminary examination results were published in Millard, the issue Millard whether we are equated on par with the fresh candidates, that was came into light. Earlier, because there was no marks specified for home guards, we are under the impression that we will be treated separately. Millard, when the results were published in prelims inquiry, Millard, then we came to know that we are equated on par with the fresh candidates who are disqualified and insisting to secure the same marks, which is contrary to the earlier division bench judgment.
I'll see the division bench also. Different. Yes, ma'am.
Rashmi, kindly see paragraph number 31 at page 246. The judgment in Anupal's suit was discussed, Your Lordship. This with the filling of posts through direct recruitment and where the rules were subsequently amended. In the above judgment, if a suitable candidate for filling up the vacancy reserved for such post of horizontal reservation is not available, the same will not be carried forward and the same will be filled up by another suitable candidate amongst the candidates belonging to vertically reserved categories according to their merit. This issue deals with their contention that the remaining posts should not be filled with direct candidates, but it has to be reserved for home guards alone for the next recruitment notification. That is the contention. Answering that, Your Lordship, this was discussed. In the case at hand, in the absence of any suitable candidate in a special category, it will be filled up by direct recruitment as per notification. As discussed supra, out of 1167 posts reserved for special category, only 110 or 120 candidates from home guards were qualified in preliminary written test. Thus, by creating a right on one hand and taking away the right on the other hand, government has taken a calculated risk. The observations end there. There is no direction in furtherance of that. Because the Honorable Court felt that the government has taken a decision and as per that the notification was issued. And the notification was not under challenge at any point in time, except for now when the learned senior has brought forward the amendment to the prayer.
Okay.
Thereafter, Your Lordship, that is the second point. Third, para 36.
Okay.
Made it from 35 onwards, Your Lordship. In the recent judgment in civil para 35 at page 249,
Yeah, go ahead.
page 49, para 35.
They all participated in physical tests.
Not all of them, Your Lordship, because after they filed this round of writ petitions, they got an interim order to continue, to permit them for further rounds. However, because the learned single judge had specifically stated that merely because by virtue of interim orders you participated in the next rounds, if you do not have the eligibility criteria, you will not be eligible. You cannot claim any.
No, I'm only asking whether did they participate at all.
They did not. They wanted to. When writ appeal was filed against the interim orders in this round of litigation, writ appeals were filed and the order of the learned single judge was modified and they were not permitted.
They permitted them. You would have known where they stand.
So the process.
No, back then
The second round they have.
they have qualified. Anyway, go ahead.
The preliminary written test they did not qualify. They do not qualify for the eligibility criteria also, but merely by virtue of the interim orders in the writ petitions,
All
they
right.
were.
All right.
Para 35 at page 249. The recent judgment in civil appeal number so and so dated 4/9/24 the Honorable Apex Court considered whether an individual who applied against the quota reserved for ex-servicemen is entitled to the benefit of relaxation in qualifying marks in the main examination available to candidates belonging to SC, ST and other reserved categories. The Apex Court answered the question negatively and held that there was no right vested in an applicant to claim relaxation in qualifying marks on par with the candidates who have applied against reserved categories. Thus, considering various expressions of the Honorable Apex Court, this court is of the opinion that mere participation in the preliminary written test will not amount to acquiescence in the facts of the case. The petitioners are not asking the second respondent to relax the marks because this prayer, Your Lordship, was not pressed during arguments. The petitioners being a special category, they only restricted thereafter, after a certain time of hearing, they've restricted to, they've requested the Honorable Court to decide whether inter-se merit list has to be prepared or not. Therefore, all the aspects were argued. However, ultimately, they said we'll restrict to this. We are not asking them to relax the marks. That was a specific statement that was made.
Yes.
The petitioners are not asking the second respondent to relax the marks. The petitioners, being a special category, in view of the order in OA number so-and-so and batch and confirmed by the division bench in so-and-so, are canvassing to prepare a separate inter-se seniority merit list among themselves and thereafter apply compartmentalized horizontal reservation. Given the discussion supra, substitution of Rule 3C by GO 87 will not create any restrictions on the second respondent to prepare a separate inter-se seniority merit list among the special categories. Second respondent thoughtfully applied the compartmentalized horizontal reservation to the special representation, that is special category. By doing so, reservation will not exceed 50%. Thereafter, Your Lordship, I kindly come to the conclusion. Page 252. Given the discussion supra, para 42, all the writ petitions are disposed of with the following directions. Second respondent shall prepare a separate inter-se merit list in respect of home guards being a special category. This has been done. Amendment to Rule 3C of the special rules will not come in the way of second respondent preparing a separate inter-se merit list among the home guards. After preparation of the set list, the second respondent shall apply compartmentalized horizontal reservation in respect of each category as per the notification. Regarding the local candidate issue, this is not in dispute now. The second respondent shall complete the exercise as expeditiously as possible, preferably within 6 weeks from the date of receipt of copy of this order. Petitioners in the above writ petitions shall not claim any vested right because of interim directions granted pending the writ petitions. Those interim directions or protections are granted, enabling the petitioners to participate in the second level examination only, of course, subject to the preparation of separate inter-se merit list. This is the final observation.
So it's filed after the preliminary examination.
No, this was, yes,
It was filed after the
After the
preliminary
preliminary.
examination.
because they could not call it.
We are going to physical test of issuing the hall ticket for physical test. We are stopped. Then we. This court has permitted. Techniques has been withdrawn. Day before rest.
Therefore, that is the order of the learned single judge. Your Lordship. Now the petitioners are seeking to raise the same grounds once again in this round of litigation. It has already been decided. All the points that were raised have been argued at length.
Okay.
Now, Your Lordship may kindly, even now, they do not challenge the notification. Lordship will kindly see the layout in this very writ petition.
This writ petition, they are seeking for relaxation of marks and physical.
Now, once again seeking for relaxation of marks.
And
The
physical,
earlier round of litigation also the prayer was the same, seeking relaxation of marks. Because your lordships have seen, initially the learned single judge had recorded what the contentions in the writ petitions were. The very first paragraph that I read out to your lordship at para 8A. Minimum marks prescribed as per clause 20 do not apply to that category. That was the specific case. Thereafter, they chose not to press it, which was recorded. Prayer was the same. Now they cannot once again raise the same prayer, is my humble submission. I can demonstrate your lordship with the prayer. I may have permitted to on the next date of hearing the case status in that particular case, so that the prayer in the both the writ petitions will become very clear.
that will be there at initial pages itself. It's okay.
That will be my basic submission, your lordship. Rest of it, my request to your lordship to kindly accommodate the learned AG to.
What do you say with regard to this not pressing of marks, which is at page para 37?
Still also we will stand up on the same side, because our contention is not relaxation. The notification deals with two type of candidates.
General and ex-military.
Definitions. The marks, our contention is the marks prescribed for only for fresh recruitment candidates, direct recruit vacancies. It is not relating to us. Therefore, the home guards, they among their merit, inter se in a descending order should be prepared. Since there is no qualifying marks prescribed for home guard category as prescribed for ex-servicemen, where our merit not basing on the home, suppose I secured 90, secured 89 like that. In the descending order of the home guards, they have to prepare the separate merit list. Among the cutoff mark, whoever they can specify there itself. Since there is no specifying marks, we are not seeking any relaxation. We are separate category as held by the earlier litigation. Therefore, we never sought and we are not seeking also relaxation. That is not the case, not in either the cases earlier litigation or here also. Our case, specific case is we are separate category and we cannot be that marks specified is only for fresh recruitment, not for home guards. That was accepted by the earlier litigation. Still they are canvassing, in spite of the division bench judgment, still they are issuing notification for the same, the earlier notification also same.
What is the division bench judgment that you are referring to?
1142 page number.
What are the division bench judgments that you are referring to?
Division bench judgment is same issue, 3C, 3D, special category.
Special category issue here is with regard to that there is no requirement of any minimum marks.
There also, that was already decided.
Just show me that.
I request your lordship, page 215.
Okay.
215, para 6.
Para 7.
State answer. This court notices that the petitioner may read. This court notices that the petitioner in this case is home guard. There is no dispute about this fact. The tribunal notices that as per the notification, minimum qualifying marks are prescribed for various categories and communities for selection to the post. For the police constable in the written examination,
1 minute.
And a candidate belonging to SC/ST ex-serviceman has to secure 30%.
This judgment is also dealing with 22 notification.
Not Millard, it is a 2011 notification. Notification. Except 87 GO Millard, everything is Millard the same. Now for this recruitment, 87 is incorporated.
What is 87?
87 Millard horizontal reservation. We are also not on the point now because we cannot oppose for the reservations, which is a policy decision. That will come in the later stage when the final merit list is prepared. Then they have to adjust against the roster points. There, one small objection for us because while filling up the vacancies of home guards, no RO is followed. The rule of reservation was not followed for appointment as home guards. If suppose if home guard category, from home guard category to appointment for PC candidate, if ROR is implemented, there will not be a sufficient candidate from the respective communities. That is the only objection. That is why his lordship, the earlier lordship said that government is taking a risk by calculating that. Because when you are not followed in the feeder category, rule of reservation, when appointment for further appointment from that category, how if the rule of reservation is listed, it will be more injustice. It is nothing but giving it one way, taking away the another way. Your lordship kindly see that judgment paragraph. I will do. Just now, my friend read out. Para 32, page 247.
Calculated risk that I have seen. Calculated risk.
Yes, ma'am. That is the reason why his lordship used that word. Nothing is decided. The lordship said you prepare seniority list as per the earlier judgments, and referring to the lordship already we referred all the judgments cited by us in the respect of the earlier notifications. Your lordship said we prepare seniority. None of the directions were followed. Preparing separate merit list, applying same marks, Millard will not do any justice. The finding is in the earlier litigation, division bench and the tribunal, separate merit list among the performance of the home guards. So his lordship, Millard, you consider all those things and prepare separate merit list. Now they said they applying the same marks and disqualified us, and that is not the purport of the order, Millard.
Apart from this division bench, what are the other judgments that you are relying on? Division bench.
On this aspect, say regarding the respondents relied on the horizontal reservation and those things. On the aspect of the point involved in this case, those were the judgments, and division bench judgments in respect of page number 188. Regarding this is regarding the SI selections, the same recruitment, same issue. Page 198 and 192, two judgments I filed. and constables are concerned, this issue is already decided, but the respondents are not following. That is the complaint before your lordship.
All right.
Some of them failed in preliminary. Some of them were disqualified in events. If they not purport of that special category and judgment principle that separate performance is created and the separate merit is prepared in the descending order, when we would have get at least 60 to 70% of candidates who are working for 30 years, 40 years.
There is a age limit for you also, Kada? There is a age limit also for you.
Yes, yes, ma'am.
How can you work for 30, 40 years?
24 years, 30 years.
How can you work for 30, 40 years? Cheppedam.
18 to 20 years they are working most.
Outer limit of age is 24.
No, we are 39 years home guards.
What is the outer limit?
Working for fresh candidates, home guards are concerned with 39 years.
39 years.
SC/ST is 42, 40. All benefits are given, once they are giving in the left hand and taking away in the right hand.
Okay. What is the outer limit, age limit for ex-servicemen?
32, 42. There, lordship last occasion also posed the same question. Ex-servicemen are concerned. They are working for a particular time. They are either coming out from the service or they are practicing a preparation program. Whereas we are concerned, on the day of examination also we attended the duties. So many people, no leaves, nothing. On the day of examination, the 2 o'clock exam means up to 10 o'clock they are in the office. They were not permitted to leave the. That is the heart burning of the petitioners. So that on that aspect, you lordship may need not compare with the service of ex-servicemen and home guards.
What is the comparative yardstick then?
Comparative yardstick is only to the since we are.
No, you have to look at it from the post that you want. So the police constable requires certain physical parameters.
Sorry.
Fitness issues untai kada. So whether police constable, what is the parameter, comparable parameter entailed? Because you need to look at the post you are looking at. How do you, where do you want yourself to be fit in? You say you can't even have physical parameters, no qualifications. Suppose an investigation cheyali. Investigation cheyali, some crime. Are you going to say that no, we are, we should still, though I am not able to do investigation because I don't have minimum marks, still I should be recruited? You will have to look at it from the post you are aspiring for.
With respect to the lordship.
పర్వాలేదండి నేను తప్పంటే చెప్పండి ఏం కాదు.
We are already discharging same duties as a home guards. We are interested in all the works from the housemaid to investigations, and the home guards are exhibited more efficient service in the tracing out the doing investigation culprits. They are done best work than regular police constables.
Okay.
Since we are serving the same department, we are capable of doing, and we are only asking not to totally shut down our eligibility, testing eligibility. At least we use separate qualifying mark, and for 830 minutes, 8.30 minutes for general category candidates for completing 1600 meters. We increase it to some 4 minutes, 3 minutes increase, and we test it.
Okay.
Separately, instead of comparing with them. For putting the persons in the rigid selection process will not render any justice because of the object of rule will not be achieved. All this time, Milord, issues, Milord, earlier coordinate bench, Milord, kept in mind, and the decision rendered, Milord, was even Supreme Court challenged, it was not stayed, stay was not granted. It was carried to Supreme Court, but no stay was granted.
Okay. All right.
Some of them qualified, Milord, in the events. Some of them, Milord, were not qualified because of equating, insisting to secure same marks. If the marks are separately, Milord, fixed up based on the performance of the home guards alone, they will get.
So there can be a cutoff mark among home guards.
Yes. That, Milord, is their prerogative. We cannot say that no.
They
But-
can have a cutoff mark among home guards according to you.
Home guards, but with not the same marks. If the same mark is fixed up and separate merit list is prepared, no purpose will serve. Milord.
Physical parameters also you're agreeable, but some different physical parameters.
We suggested. Now, Milord, almost my clients, Milord, the events, so many people are qualified, events also. Milord, they secured lesser mark in the prelims, therefore they were not sent for next further process of third level examination. So my clients, almost all, Milord, they are qualified in prelims events. Here, three types we can calculate. The persons, Milord, underage, lesser height. They can be thrown out separately, Milord, their cases has to be dealt separately. Next thing, Milord, those who are attempted, not secured qualifying marks, fixed for fresh candidates. Those candidates, this category separated. Those persons who are already passed with prelims and events and who failed in the main examination. The three categories.
Third category మళ్ళీ చెప్పండి.
They passed into first level and second level. They failed in third level.
What is third level?
Third level main examination, Milord.
What is second level?
Second level PET, Milord, events. Some consideration is required, Milord, because
All right. In the case laws which have been referred to in all these judgments, was there any reference with regard to relaxation to be provided for a separate class?
that is decided in only our judgment for police constable's case, that is division bench.
The earlier round.
Age relaxation, Milord, I am not representing, Milord, I have not filed any case because I have not prepared anything on that age relaxation because
Age relaxation కాదు, with regard to the parameters in qualifying mark.
Lordship, has to now. Lordships.
Okay.
Because of earlier division bench based on that, Lordship can or suggest the department will learn to expose our grievances.
All right.
Like,
Granted in favor of the home guards quota.
Sorry?
Out of 6,000 posts, they are given quota for home guards for that purpose. Sir, without having any qualification mentioned in the notification. Earlier,
You are agreeable for any qualification to be fixed as on date. No, even if today they fix a parameter, it's okay for you. No, I am asking whether you will tomorrow turn around and challenge. They are saying that no qualification was prescribed, therefore no qualification can be prescribed now. I think Anupal Singh, that is a larger bench decision, and Anupal Singh, where Supreme Court said that the parameters cannot be changed after notification is issued.
It has been discussed at page 240.
Is that the judgment, larger bench decision of Supreme Court?
Vacancies of horizontal reservation filled by candidates of vertical reservation.
I think their rules of the game cannot be changed after the notification is issued. And there is a larger bench decision. What is that judgment? Because I think some leeway is given.
27 it was discussed. Page 245. para 27, 28, 29. Two judgments were
No, these are all
having
five.
participated and being unsuccessful. They cannot turn around and complain about infringement.
No, no, larger bench decision is there. These are all referred to larger bench. I think sometime in 24 or so, there is one more judgment.
There are 34, Miller. There are 34, page 249.
What does it say?
Fixation of general standard marks described.
Yes, yes, judgment.
State of Orissa versus Muhammad Yunus, 1994 supplement 2. SEC.
Yes, yes. This I've seen. Okay.
For a moment, Miller 125 in the same page. 125.
125 page number. Huh?
Page number 125.
Okay.
Last top Miller para, class 10. This is notification. The Police Recruitment Board AP reserves the right to issue corrigendum supplementary notification time to time case in the any modification in the rules or any recruitment process is required. By virtue of this, his lordship said that in the earlier judgment also, the power is vested with the government. They can. So we are not asking any standard modification. As it is, you implement the rule. That's why we are asking.
All right.
If necessary, the power is vested with the notification itself. They said that we have, they can do it now also. Their hands are not tied. Therefore, those judgments, honorable apex court judgment may not come in our way. It is a prerogative of the government. My instructions are, government is also ready to do, but the officers, who are the coming in our way to get the benefit. Though government gave a benefit, the officers are not interested to extend it.
The larger bench judgment, Your Lordship, is Ashok Kumar was the state of Bihar. So 3-judge bench.
It's a bunch of 5 judges. Tej Prakash Pathak versus Rajasthan High Court. Tej Prakash Pathak versus Rajasthan High Court. Okay. All right. Right. Okay. Aros Itrigan. Last when I conclude, you can pass. All these things will be misplaced. 75 case number. Of contribute.
80 millet. 80 repetition 7897 of 25 millet. This is the height issue millet. Earlier round of save notifications issued by the respondents only, they are qualified in the SI examination also. Now in this examination they are disqualified.
Okay.
Height issue and height flow
No, why are you disqualified? Is the height is qualification of height is increased in the present notification?
only to measuring the wrongly they are disqualified.
Why will they measure wrongly for you?
They introduced a new system millet larger system. That is the difficulty. Earlier 2-3 rounds they are qualified millet. Stated so in my affidavit.
Sir, that is not an issue.
23.
Page 128, Milad. I have given the table of the petitioners.
One 128.
Exhibit 67. On the petitioners, Milad, 1400 meters. Yeah, we are supposed to run Milad 1600 meters, 8.3 general candidates. But the home guard petitions only 8.34, 8.01, 8.31, 7 minutes also they qualified. So, prelims Milad, the marks they insisted to score the 80, 70, 60. Therefore, we are disqualified. Likewise, I mean, my all cases Milad, I have filed the table forms to seek your lordship's indulgence to if that cut off they fix up separately to home guards, they will get some benefit.
Page 128.
128.
ఏం చెప్పారండి? What did you say? Sorry, I lost.
Home guard number, prelims examination, marks, prelims exam, 71. 1600, 8 minutes they have to run. I run 8.34 seconds. Likewise, the timings.
ఆయన ఎవరండి?
Home guard, sir.
Page 42, item 42 ఎవరు?
Item 42.
2 minutes 11 seconds లో రన్ చేశారు.
Mahmood Prabhani Sheikh. 2 minutes, 11 seconds. 53 marks he secured.
All right, I followed page 120. Yes, ma'am. When do you want it? Tomorrow it won't be possible.
Subject to your lordship. Tuesday.
You need to close it on that day.
Yes, yes, certainly. I apologize, your lordship, for the inconvenience.
What time I'm adjourning it?
I understand.
ఏమైనా ఉందండి మీ
Closing will not trouble you.
అవును నా ట్రబుల్ ఏం లేదు, మీరు చెప్పండి వింటాను. అడుగు చెప్పమంటే మరి ఏం లేదంటారు ఇప్పుడు. What are your arguments? Just give me a list of those dates and the events you want to rely on. Under compiled ka ఒకటి ఇవ్వండి.
For my cases, 3 cases I find.
Ajay Kumar గారు దాంట్లో కూడా కలిపి ఇవ్వండి, because it becomes easy for me to refer the cases. I can ఆయన మీ citations ఆయన ఇచ్చిన మెమోతో పాటు ఇవ్వండి. I know what your case is, but for me to refer, it is easy. అయితే సెపరేట్గా ఇవ్వండి, చూస్తాను. సెపరేట్ బండిల్ పెట్టి ట్యూస్డే థర్డ్ మీ స్పెషల్ జీపీ కదండి, స్పెషల్ జీపీ ఎస్ ప్రణతి, జి సీనా కుమార్, చల్లా అజయ్ కుమార్. For further arguments, for further arguments, post on Tuesday. Tuesday, I would like to close it, madam.
Item number 89, G. Ramchandra Reddy.